Thank you. Thank you so much. First, thank you is to Startup Boston for having us here. I always like to thank the panelists up front too, in case I forget later. And a big thank you to the audience for being here virtually and online and however else you're joining us. So this panel is all about IP. All about everything IP. How do you identify it? How do you protect it? And what are some of the things that you can start doing now to get things in order for your next funding round to make it a little less painful? We'll do formal introductions in a second, but just to point everyone out, Peter here is going to be helping us from the IP perspective, the legal perspective. Diana at the end there, she has the investors perspective. And then rounding us out, we have Nicole and Kevin in the middle. They are bringing the startup perspective to the panel today. A little bit about me. My name is Andrea Reed. I'm of counsel with the law firm of Landau and Anastasi in Boston. My background is actually in plastics engineering. I spent a little bit of time in the medical device industry, working on bioabsorbable orthopedic screws and sutures, soft tissue fixation pins. I did quite a bit of class 10,000 cleaner manufacturing. And then now having transitioned into legal, I've spent about 10 years working in IP litigation, patent litigation, trademark litigation. So with that, one last disclaimer, because I always like to put a disclaimer on the record. I'm a lawyer and I can't help myself. Everybody here is speaking on their own personal experiences. We know what companies and firms they're from, but they are not speaking on behalf of their companies or firms today. So if anyone wants to quote them, etc., please get their permission. You can ask me. And with that, let's start with Diana. You want to introduce yourself?
Sure. Thank you very much, and thanks for having me on this panel. I'm Diana Radel. I'm the CEO and founder of Deer Isle Group. And what Deer Isle Group does is it enables companies to do a direct issuance to their total addressable capital market. So everybody who could be interested in investing in the company from a universe of over 10,000 US institutional capital providers. So it's an extremely efficient way to gain capital and to gain visibility with your potential investors.
Okay, and Kevin?
Hi, I'm Kevin Kalish. I'm the COO of Enclear Therapies. We are a startup started in 2018, targeting better treatment via better drug distribution for neurodegenerative diseases.
Hi, I'm Nicole Wagner. I'm the president and CEO of Lamb Division. Lamb Division is a Yukon startup company that is developing a protein-based artificial retina to restore vision to patients that are blinded by end-stage retinal degenerative diseases. So macular degeneration is the one that most of you probably know, though we will start with the orphan indication of retinitis pigmentosa first. And the fun fact, we were actually a Mass Challenge winner of the Tech and Space Prize back in 2016. So a different building, but since that opportunity, we've been able to work with NASA and continue some of the great work that we've been started here in Mass Challenge 6 years ago. Thank you.
And Peter?
Peter Lando. I'm a founding partner of Lando and Anastasi, a Boston-based intellectual property firm. Been practicing for, well, just over 30 years now, 31 years. And prior to that, I was a chemical engineer for BASF, big chemical company, who also put me through business school. I have an MBA as well. And I find, well, I've done hundreds of diligence exercises for buyers and sellers over the years in different technologies, medical devices, chemical industries, mechanical industries, all over the map. So it's been a lot of fun. I'll leave it at that for now.
Peter could go on for a while, so we're going to stop him. I like to start with a preview of IP and a preview of due diligence. I never want to assume anyone in the audience even knows what a patent is. I think we have people with a lot of different backgrounds here, some who are just getting started in this area, and some people who have been there, done that 3 times now. So I want to start with a little bit of what is IP and why is it important? Peter, I'm going to throw that one to you.
Oh, well, intellectual property can be your most important asset, and it should be. I'm biased, of course. We'll start there as a kind of a top level. Of course, it's made up of 4 categories. We talk about copyrights and trademarks and patents and trade secrets. Let me just quiz the audience just real quick. Does anybody have a copyright? David, I'm surprised at you. Everybody has a copyright because you've written a note to your mom or something. And it's in the pen hitting the paper. At that moment, you're a copyright owner. And those of you who are in businesses or you work for building a company, put that copyright notice on your work, right? Copyright, seen a circle, we've all seen it, the date of publication and the owner. And trademarks, we're very familiar with trademarks. And trademarks come out of what's called the Lanham Act, which was based on kind of fairness in the economy, right? So if I buy a Hershey bar here in Boston, I know it's the same quality as the one I had in Los Angeles. Well, we'll put those aside for the moment. When we think IP, we generally think patents, I'm guessing. But you might be surprised to know that trade secrets make up the majority of intellectual property. About 80 to 90% of all intellectual property are trade secrets, if, big if, you maintain them. And we can talk about that now or another time. Patents, of course, have to be new, useful, and not obvious. And that's where it's that last one, that's the gatekeeper. And it's the one we have most challenge with the patent office. But there's a lot to say about patents. Do they cover your product? Do they cover your service? Do they cover features, important features of your products and services? Just having a patent used to be enough. And now the investors are asking, what does it cover? How good is that patent? Do you have international rights? And as I say, I can go on, but patents are very valuable. You got to do it right.
Thank you, Peter. And Diana, you know, that's a good segue for you. I was going to ask, what is due diligence and why is that important? So maybe you can answer that while you're building on Peter.
Sure. So investors, before they're going to make an investment, they want to make sure that your assets are protected. And that's essentially what a patent does, is it protects the asset of your intellectual property. And so when an investor wants to make an investment in a firm that has, sort of intellectual property, then they'll sort of look and make sure and do due diligence to try to make sure that that intellectual property is protected. And so they'll look at your patent. And as Peter was just saying, there are different aspects that they'll take a look at. You know, are you protected internationally? Are you protected for the use that you're saying that you're going to use it for? Are you protected, for one piece of your process or your asset? Are you protected for the full process? So there are many different aspects of an investor looking at what that patent is and how it's been filed and how it's been approved. And that's why you need law firms to help you, because it's quite complicated. And the final thing I would say is a patent is just a patent. Then they need to know how you're going to use the patent to make money so that they can get their return. And that's one of the most important parts of due diligence. And that's one of the things that when, companies are so excited about their patent, they kind of start to forget, like, gee, this is actually, if I'm going to find an investor, I actually have to find somebody who's going to agree that the amount of money that I think I'm going to make from this patent, minus the cost of producing whatever it is actually going to produce a return that's attractive to that capital provider. So that's one of the most important parts of the due diligence process.
I just want to, at this point, if you don't mind, add about patents. Patents are, if they're granted, they give you a right to exclude others, okay? Exclude others is not a right to do. They're so often mischaracterized in the media as monopolies. It's not a monopoly. It doesn't give you a right to do anything but exclude others. So someone might have a patent that excludes you, even if you have a patent to do it. So that's the type of diligence inquiry. It's got to go much deeper.
I'm going to throw a question to our two startup reps over here. We talked a little bit on a pre-call about IP and how do you identify the scope of your IP? How do you even know what your IP is? Now, Kevin, I know you're an inventor on a couple of patents or patent applications. Do you want to talk to us about your experience and how do you identify an IP for a startup?
Yeah, great. The way we started, and I did this previously to Enclear at a large pharma company as well, was we started off with some ideation sessions. And for the most part, you have a scope, you know what your company is, you know what you want to be, and getting the right people in the room to have these conversations, kind of in that general realm. And it's, brainstorming. There's other terms I've heard. My favorite one I've heard recently was burning toast. for doing these meetings, where you don't have the wrong answers. It's just try to come up with a landscape. From there, we whiteboard, kind of narrow down, get some sub teams together, and really try to dive in. There are great tools out there from startups such as the U.S. Patent Office for broad landscape, and this is all done internally. Lawyers are expensive and they're very talented, but you don't want them too early. And so we would come up with the 2-3 kind of broad scope statements that we're looking for, and then at the right time we would pull in the lawyers to help us flush out what is your novel claim and take it from there, and let them work on the appropriate verbiage to legal them up. That's not my expertise. It's not anyone on my team's expertise, nor should it be. We're trying to come up with something novel. And then that's where the partnership really starts to say, what is novel?
Thank you. And Nicole, what about you? What's your view on that? Identifying what your IP is at an early stage?
Yeah, I mean, I think for us, what we did is we really, similar to what Kevin did, is we sat down and we thought, what is unique about our technology? What is novel about our technology? But also, does this technology have something that can be commercialized? So often people get really excited about how cool their technology is. It's so new. It's so unique. Oh my gosh, I'm going to do all these awesome things with it. And you can never monetize it because it doesn't, maybe there's no commercial pathway for that. So in addition to thinking about the great science that's there, you really need to sit down and say, all right, why am I doing the patent? Why am I filing this? What am I trying to exclude, to Peter's point? And how are we going to make money off of this? How are we going to monetize that? So, when we started early, we did this actually, I'm a spinoff out of the University of Connecticut. So we actually sat down with the IP team, the commercialization team at the University of Connecticut. We talked about what we thought was novel about our process. They pushed back and said, hey, do you have a business model? And we said, yeah, we have a ton of business models. And they said, no, let's try this again. What is the real business model here? And then we actually spent more time on the market and market size and identifying that, rather than what was really cool about our technology and what was novel about our technology. Once we had that, and only once we had a market, did we then go ahead and actually go push forward with filing the IP.
Yeah, that's really helpful. And after just saying not to quote anyone without their permission, I'm going to quote Diana without her permission. Something that she had said before this session. Here, I'm reading it. Just because it's cool and patentable doesn't mean there's a business opportunity. But sometimes you still might want to go for something anyway, because even though there's not a clear use case right now, there might be in the future. Peter, I don't know if you want to talk about that a little bit, how you might align it with the business plans, either now or a future business plan, and deciding what your IP is when you're identifying it.
Right. That's certainly a useful exercise. I did want to touch on one thing, though. I think you have to be sure you can do what that novel or new idea is. You did a market analysis. Can I do that? So you've all heard the phrase of a freedom to operate. And so investigate what third parties have. What's the point? I mentioned a moment ago, it's a right to exclude others, but not to do. So I can have a patent and not do it. So I should invest some of my time in a freedom to operate search and analysis to make sure I have at least a pathway toward where I want to be. And once I discover where I want to be, I kind of look at this as a dot on a page. All right, that's the invention, and I have to look at the ecosystem around that dot on the page. Are there suppliers, multiple suppliers, sources of the things I need to make my product? So what's upstream? What's downstream? Is there a market, or do I have to create a market? Are there disruptors out there? The internet was a tremendous disruptor in so many industries. So do you have the foresight to think around what the target, what the invention is? And if you do, my suggestion would be not only patenting the target, but expand that umbrella, that penumbra around that target, and say, I'm going to get patent claims that include the supplier as well as what I'm doing. I'm going to transform something into what I've got. Now that supplier needs me. And I'm going to get patents around what my customers do with my product. Now they need me, right? And I'm going to try to box out these competitors by claiming it a little broader than it's just the dot on the page. So like the circles that form around a rock that goes into a pond, that's the way I think about in patenting. So you get a little more value there. I'm sorry, did I answer your question?
That was amazing. I didn't ask that question, but I'm glad you answered it because
I lose myself. I mean, some people here know I lose myself. Sorry.
Sometimes I just let him go, and sometimes I have to cut him off. I never know.
All right.
No, well, you know what? I want to go into freedom to operate, and I think this is a good time to do it because you had brought it up. I'm going to poll the audience because that was fun. How many people in here know what freedom to operate means? Okay, all right. So we got a few on. Do you want to talk about that, Peter? Or I don't know if anyone else.
I'd love to hear the experiences on the panel for freedom to operate exercises. You have businesses up and running. I'm sure your investors wanted to know who the competitive landscape, or who's in the competitive landscape, and who. Right? Are they other startups? Or are they big multi-billion-dollar companies?
Yeah. I would maybe just say something about the competitors. Like, so many companies feel, if I can just show that nobody else is doing this, this is great. I'm going to get lots of investors. But the fact of the matter is, if nobody else is doing this, maybe there's a reason. So you need to think hard about, is nobody else doing this because there's a reason? Costs are more expensive, more than you can charge. There's a lot of, replacement products, or is it really disruptive? And there is a place for your product in the market. And if it's disruptive, then you have to think about, what is it really going to cost to educate, let people know what it is, get them buy-in. There's a lot of work that goes into disruptive. So oftentimes, people say it's the second company that actually makes all the profit. But anyway, this is something to really think about under this freedom to operate, and really think about, like, again, getting back to some of these points. What is the business opportunity here in addition to what is the patent?
Diana, what stage are you looking for freedom to operate to have either already been done or something that's in the works? Is there a particular business stage where you want to see that's happened?
I mean, I don't think there's a defining line. It's just that the earlier that you are, the harder it is to find capital, right? So if you have freedom to operate, you've proven that, you can operate. That probably means your company is Series A, maybe, you have revenues. And so that obviously is a lot easier to raise capital than, a company that's earlier stage that's still trying to figure out if they have freedom to operate and where they might actually land in terms of the ability to operate. So I think, investors, it's all about risk return profile. So, if you're earlier stage, then you kind of have to have a higher risk return profile because you're higher risk. If you're later stage, you can have a lower return profile because you're lower risk.
Okay, that's helpful. Nicole, I don't know if you wanted to add anything.
Yeah, I mean, I guess what I would add to it is, I think when I was sitting in your seats a couple of years ago, when I would hear these people talk up here, oh my God, IP, freedom to operate, I was like, this is expensive, right? I would get so nervous, and you're like, there's no way I can do that. How am I going to work with people? What I would say to that is that all of the things that we're talking about here are really, really important. And from an investor and actually getting your company funded, even from whether it's private investors or even grants. So we're primarily grant funded. They're going to ask, have you done a SWOT analysis? One of the things that I found most useful very early on, before I did, a freedom to operate, was to sit down with a lawyer and talk about my strengths, my weaknesses, my threats, and my opportunities. So are there, what is Lambda Vision really, really great at? What competitors are out there? What are our threats? What opportunities, they're going to be the first to do this? Is there nobody else in this landscape that we're doing? And then what are some of your, what are some of the weaknesses that are out there? And so that was what decided, kind of pushed us to where is that weakness? Is it we haven't really done a freedom to operate? Do we need to spend more time thinking about is patenting globally, broadly, the best way to do this? Do we need to just focus on the US market? So I think that's all important. So that was my one point. The other point in terms of freedom to operate, I mean, we did sort of, there's all levels of freedom to operate. I think you can do a really robust search. And if you're going to get investment, the investors are likely going to require at some point you do an FTO, and it's, you'll do it formally. But it's better if you can do it ahead of time, or you have some level of documentation that can say, hey, we've looked at this. I'm going to just take that right off the table. So let's start talking about something else, because it helps the diligence process move a lot faster. And when you're at that stage and you're looking for capital, you want to have that capital to move your company forward, because so much of it also is how fast can you get to market? How can you do that return on investment?
Yeah. From our experience with Freedom to Operate, we closed a seed round and then later an A. On the seed round, quite frankly, the credibility of our patent lawyers alone was enough to kind of justify the Freedom to Operate. We were asked some questions. We weren't asking for a ton of money, but just the credibility of having a good legal representation was enough. We didn't have to do a full formal FTO. When we did our Series A, it was different. There was real money there, and it was a much higher bar to jump over. We also had probably 5 additional disclosures that were in at that time. So the nature of our business had changed. We were growing. We were looking for more money. And all the stuff that Nicole said came up around, SWOT analysis and how you're going to go commercial. And that mattered a lot more at that time. We still weren't at a stage where we're getting the full formal legal Freedom to Operate. It was able to handle lawyer to lawyer, but the level of diligence, the level of digging in, and the level of expertise that was pulled in to the analysis was all elevated. For our next round, we will probably be at the stage where we'll need the formal legal opinion saying, yes, we have Freedom to Operate in the key spaces for our key markets.
Thank you, Kevin. I'll say, if anyone wants to ask a question, I think that that you feel free to do it. I know Cam's over in the corner. He can catch anyone who's raising their hand. So if you, okay, we have a question. Well, everyone looks so interested and attentive, and I want to make sure if you have things that are going through your mind, we're here and we want to help you, and I want to make sure that we're hitting those points.
Cool. Could you talk a little bit about, I guess, trade secrets or the use of like open source algorithms? So we're not like in biotech. I think it's pretty clear. It's very, very big issue. We have a product that is using some open source natural language processing algorithms and applying them in a novel way. And we're trying to figure out, like, is it worth going through the exercise to even think about anything that's protectable? Because fundamentally for our business, it's about user engagement. Like, if we have users that can't live without our product, it'll be very successful, even if we have no IP, but we'd like to try to put some moats around. So I don't know in the enterprise software space, if anyone could comment on that.
Well, I think using open source creates risks, of course, but I have worked with companies that have patented putting these things together, the bridges, the connections, and then, of course, the applications, the user interface. So I think there's ways to patent things and avoid open source as far as patenting goes, but the open source agreements do open you up to some issues with regard to those particular softwares. So there's different questions.
Interesting. So in your example, that would be considered like a process related?
It could be, yeah, certainly. Or system.
Is that becoming more like watered down in terms of like the ability to defend process related?
Oh, yeah. Usually method claims and process claims, yeah, they get a bad rap. They could be written well enough with some foresight. Remember, I can give you several examples. You just make up what you're claiming. I mean, as a patent attorney, so a method of doing something, fill in the blank. You don't have to stick to any rigid formula. There's generally 2 categories, right? So there's apparatus, method. Okay, so here's an example. We have a client that does a lot of work with municipalities, and nobody wants to sue a city or in certain industries. So what we did was we started claiming things, method of facilitating something. So I'm enabling you to do something, but it's not that you're doing it, it's that I'm enabling you to do it. So who would be a defendant there would be my competitor that also facilitated the use. So I don't want to sue the city. I want to sue the supplier. So there's ways to be creative to claim. There's very strong method and process claims out there. If there's markers, for instance, that you had to use this process, right? There's some residual or some marker. The other benefit I don't know if we want to talk about international rights at this point,
No,
but U.S. method
I was
patents.
going to segue into
Yeah.
trade secrets because
Oh,
I'm glad that you
yeah.
brought that up, and we talked a little bit about it before the panel today. I know Nicole, you had some thoughts on trade secrets in different kinds of industries and spaces. I don't know if you want to start chatting about that.
Yeah, I mean, I guess as we're moving into doing work in an aerospace industry, I mean, some of it is how hard is it to get there, right? And some of these things are, can you get there the fastest? Who can do it first? And so we have thought a little bit about it. I think there's a formal process to actually go about some of this, which we have not done at this point. But these are discussions that are continually, that are ongoing. I don't know if anyone else here is, Kevin.
Our trade secret game is weak. That being said, only recently do we start really formalizing a process for it, because patents are sexy, trade secrets are not. I mean, it's good to look your name up and see it out there. It's easy to sell that, but the trade secrets are just much harder.
If you need a soundbite quote from today, then
Yeah. Yeah. So yeah, it just hasn't been a major focus for our company until recently, but we do have some valuable trade secrets that have come up, and it's definitely something that, hindsight being 2020, we should have jumped on earlier. We didn't get burned by it, but definitely an area that's been a focus.
And Diana, what's your view on if a startup comes to you and says, we have one patent but a ton of trade secrets? I mean, do you have a preference in terms of the way that the IP is split?
What's my risk return? I mean, it really does, for the investors, boil down to what is it worth in terms of revenue minus expenses, and is there a return there? And is the return high enough to compensate for the risk? So I wish it were a more complicated answer. And many companies don't understand that this is the core of the investor language. There's a lot that goes around it, but this is kind of the core, I think.
Thank you.
Well,
Peter's dying to say something. Go ahead, Peter.
Trade secrets are very interesting. And often I'll ask a client, do they want to patent something that they're working on? They say, no, we'll just keep it trade secret. I hear that a lot. I say, really? I said, what type of policy do you have to maintain that trade secret? Because if you don't, it's at risk, right? And so it's as valuable as the efforts made to keep it away, right? It's not knowledge generally known, and it's knowledge, and it could be as simple as a supplier list. It's knowledge that helps your business, gives your business advantage, but it's not generally known. So you have to make what's called reasonable efforts to keep it secret. Now, what's a reasonable effort to a company like Microsoft is way different than what's a reasonable effort for a young company. Keeping that in mind, but it's at risk. But you mentioned risk reward, right? So you get certain terms for the registrable rights. Copyright has a term. Trademarks have terms. Patents have terms. Trade secrets have no terms if you can maintain it. So a policy is a good idea, trade secret policy, and you'll have contracts and the like to have employees sign. But that's the lock on the door, right? That keeps the honest people out. So I think trade secrets are, if it can be maintained as such, is a very valuable thing. I'm curious, if I came to you and you're an investor and I say I have trade secrets, and you say, maybe cynically, you say, well, show me. I can't show you. So where are we? We're loggerheads. So there's certain amount of disclosure you can make that could prove to you that I have some knowledge. There's ways to do that. And for investors, they sometimes will ask for escrow the actual trade secret, the formula or what have you. But trade secrets are with us whether we realize it or not. This came up with the WHO asking about the vaccines and the patents, releasing the patent rights to the low and mid income countries. I can give you all the patents. Here's all the patents. You can't do it because it's the interstitial knowledge, it's the knowledge between that's not said in the patents that opens the lock, right?
Yeah. And I would also add that, I mean, from our perspective, from the investor perspective, companies come and they believe that what they have is super secret. And you're kind of like, you have to be able to talk about what it is that you have, or else nobody's going to know what's so valuable about your secret. so we putting together a company is so much more than your secret. So, we basically say, yes, you have to be very cognizant of what's valuable and what should be kept proprietary, but you also have to figure out a way to discuss what it is that you have, such that, people can be convinced that you're going to make them some money from an investor's perspective. And so when, somebody comes and says, I have trade secrets, I think that's valuable, but again, you kind of like, some people like, I'm not going to tell anybody anything about my company until I get an NDA signed. And you're like, well, nobody's going to sign an NDA until you say something about your company, right? So, it's like,
Does that reveal a certain naivete if a
yeah,
company says to you, an investor, sign my NDA?
yeah, yes. If it's before you, can show any presentation, any 2-page or anything, sign my NDA. I can't say what it is. Yes, it shows. Yeah.
We have someone who's waiting patiently for a question. Would you like to?
So coming back to trade secrets, from a company's point of view, is there a need to formally define what is our trade secret and what is not? I'm asking because recently we found, we had an experience with NDA agreements or rather definition of confidential information. And some companies would file back and say, okay, we protect your confidential information, but if you're going to share some trade secrets, oh my God, that's a completely different, we can't even have you share our trade secret. So there is a difference. It's not like, so is there need to really formally define it within the company internally?
Absolutely. Yeah. You should put boundaries around what those trade secrets are. You should limit who sees all of it, right? So it could be part that's confidential and that's confidential, and it's secret the way they work together, the two confidential. So there's different gradations, right? Confidential, proprietary, trade secret. Trade secret, you should limit access to trade secrets internally, I mean, as well as, of course, outside. So if somebody signs an NDA, did I understand that right? Somebody signed an NDA and they'd find confidential information in the agreement, I trust. Yeah. The agreement defined what that.
They were fine with sharing confidential information, kind of what was two-way NDA, but they deleted the phrase that we're going to potentially unintentionally share trade secrets. So they said, oh no, we can't accept this. So they deleted trade secrets, not to even want to have anything to do with them, because that would require a lot of, I guess, protection on their side.
Right. That makes sense. I think they're, just keep in mind they're different, and that's a higher level. Something could be confidential between you and the parties you're talking with, but it may not be a trade secret. Does that answer your question? I'm sorry.
Yeah, it does. So we need to define them properly.
You do. Yeah.
It's a bit tricky with the software company kind of to draw those boundaries.
Yes.
Okay,
Yeah.
thank you.
Yeah.
Yeah.
Do you want to take one more question from the audience on trade secrets, and then we'll move on to back to patents? And
How do you know this question's on trade secrets?
Well, we're talking about trade secrets, so I assume any hands up right now are about trade secrets.
Maybe not.
Maybe not. Okay, who wants to go? Kim, it's your decision.
Yeah, this is my question's on patents, on provisional patent filings. I was at a company spin out of Teradyne, and they were big into patents, and we had in-house counsel and did a lot of provisionals. He went private, and I've done it at subsequent startups. But recently, I've approached other firms, and we did get patents through it, and it was successful. And they didn't take the same position. They weren't as into provisional patents. So I'm curious on your experience with them, and do you recommend them? It had felt to me like it was very helpful in a startup to get the year jump. But that's my question.
We can talk about this now. Provisional patents, right? But I'll let
You
you
want?
jump in.
Okay. Well, provisional. Does everyone know what a provisional patent application is? So you can file an application. It's called provisional application. It's not a regular application. It won't be examined. And you have 1 year to convert that provisional application into what we all think of when we think patents, a utility patent application. So you have 1 year. It gives you an opportunity to put a stake in the ground and then use that next year to maybe find partners or to further develop the invention that's described in the provisional application. They can be a good tool in certain industries that move rather quickly. Software comes quickly to mind, quickly. Many companies don't do that because they're already on next versions in a year's time. But let's for a moment just assume you're in the right industry and you're going to file a provisional patent application. Many don't do it properly. They put something in that could be a few PowerPoint slides or some quick write-up, and that's not enough. It has to be robust enough of a disclosure that could support the claims in the utility application that come later. So what they're getting is a false priority date. And so they're allowing themselves exposure to the references that are out there that come before the utility application is converted. What's more is when you make that priority claim and the utility application is filed claiming that year date, the prior year filing of the provisional application becomes public at that point, meaning I could find what you wrote in the provisional application, which was to be secret, but I can find it the moment you make a priority claim on it. So many people, to save money, file a lot of kind of omnibus provisional application with 2 or more ideas or inventions in the provisional application. That application, as I say, will be public when you make the priority claim. If you only convert and file one of those inventions, the world gets to see what your other thought was for free. And not only that, it's a reference against you if you later pursue that second idea. Was I complex enough? So provisionals could be really good. They can give you that earlier date, but it has to be written as if it were a regular application. You can't do a half job on those things. And I think many people think they're filing provisional. That's a euphemism for cheaper, and it's not my world. Sorry.
No, that's helpful. Nicole, you
Peter,
look like
what
you
if
want to
you
add?
are about to make a publication, you're going to publish something or you're going to go up on a podium and present something? Is that the right time?
Well, that's what I see a lot. Yeah, definitely before. And what Nicole's referring to is to preserve her international rights, she has to get that patent application on file before there's a public disclosure. Yeah. Absolutely. But I might ask, okay, so you were presenting, you certainly had your paper, your materials ready to be submitted. Oh, you were going really fast. Yeah.
I realized as we were getting ready that that we better file and filed a provisional, and it was hard because Dave wasn't available to find someone to move at that pace.
Yeah. No, I'm sure the patent attorneys, I know the patent attorneys in this room have been in that situation the day before. So beyond not being too courteous, it's puts things at risk. I would, in that case, have the provisional application have a single idea. I wouldn't do brainstorming in my provisional application.
Yeah, that was one of the questions.
Yeah.
I had a parallel question about timing. We actually were very concerned not about our publications or public. I, having sat on National Institutes of Health study sections for 10 years, clearly understand your ideas can walk out of the room. So that was a motivation on our company to start the procedures earlier than we really should have, that we knew our money potentially was going to be coming from grants. And
yeah, no, that makes sense. And I don't mean to demean provisionals. I'm just suggesting as a warning, they should be well written. And that's
I also think a lawyer worked with me closely. In this current culture, you cannot assume your idea is staying in the room,
right,
no matter what you do.
Right.
So I'm cynical, but that's the
no, it's you're absolutely right. And even with NDAs in place, company to company, I always suggest to clients to file.
Well, I have to say for us,
yeah,
because we had a disruptive technology, I guess.
Okay.
The first thing we spent money on was the IP attorney. before we invest in anything else. But I'm a cynic.
So I think it sounds like we all know when to file. That was an outline question. When do you do it? Immediately, as soon as possible, but do it right, according to Peter. My next question for the panel is, and Kevin or Nicole, maybe you can give us the startup perspective of this, is how do you file? What do you actually do when you decide that you're ready to file? What sorts of, because I know, Kevin, you've been responsible for the IP development. What sorts of documents or questions or information do you bring to your lawyers, or should you have ready for your lawyers?
Yeah, the way we've typically handled it, as I said earlier on, if we're going way early, is via just broad brainstorming and conversations. We all know the scope of our businesses and what we're trying to accomplish and how we're trying to accomplish that, and then a level of diligence. Always handled internally. As I said before, the U.S. Patent Office does a really good search metric there, tool there for anyone to use. Anyone in this room can use it. The tools that the lawyers have are certainly better, but the tools that are open source are good to start. How we structure it. I've always had the luxury of a couple of people that I've written or been part of patents before, and so we try to figure out what our 1 or 2 independent claims would broadly look like, to then bring that to the to the lawyers, and then we try from there to flush out something in the ballpark of 8 dependent claims, give or take a little. It's it's a little fluffy on that side, but really trying to figure out what the novel independent claims are. And something Peter said earlier that we've absolutely broken his rule on is we'll do provisionals. We'll stuff like 6 patents in there. And then when we get to the conversion after that year window, we'll suss that out for 2 or 3 or 4 that are meaningful. But that's been our process. And at that point, then we'll pull up the lawyers in and let them do their refinements.
That's helpful. What about Nicole?
Yeah, I think for us, I mean, I've gone through a lot of different phases, right? From being in a research lab in an academic group, thinking that everything I did was so awesome and we need to patent every single mutant, and realizing that those were never going to be claims that I could actually get at some point. So, kind of going back now and looking at that, figuring out again what was really, really important. Once you get to the stage where you've started a company, you leverage your board of directors or your advisors as well. One of the things that we've often talked about is kind of have a little brainstorming session. What new have you done? Could there be IP around this? What do you have to protect that? Do you have, even things like MTA, material transfer agreements, employment agreements to protect IP that's happening within within your company. I mean, there's a lot of different levels, and it doesn't just come down to straight, let's file a patent right off the bat. Some of it is the freedom of operation. What we've done there is we've had interns too, kind of tell me as much as you can get, figure it out, do the search, and usually they'll find something you didn't even think about, right? And so that's a great use. They're learning something, you're gaining valuable insight from that as well. And then, once you have legal counsel, I think the other important thing is we do sort of a quarterly check-in too, and kind of go through that SWOT analysis again. What new are you doing? Are you going to be presenting, Nicole? When you're thinking about publishing that, I'm just going to caution you, those kind of things. Did you think about it? Is there anything new there? And so we kind of go through that exercise, and, maybe it's not right now. Maybe you don't, maybe you don't tell them all the secret sauce. Maybe you're not telling them the parameters, but you're saying I'm doing it in a broad way. And that goes to your point too. And when you get to an investor and you're like, I can't talk about this. No, you definitely can talk about it. I mean, look at the method section in a paper. If you try to reproduce it, there's something in there that's not in there, and it's very difficult to reproduce because they're not telling you all of that perfect know-how. So you can definitely convey your technology without telling all of the secret sauce. And maybe you don't even want that in a patent. To Peter's point, with provisionals too, sometimes you put too much out there, and you've lost the opportunity to patent it later on. And don't forget that your patents can come back and haunt you. I mean, we are constantly fighting old patents that we filed and having to cite that as prior art. And why is this new? And how do we overcome the claim of something that we thought about 10 years ago? And then the other thing I'd caution you about is when you file and when you think you're actually going to be able to commercialize, right? So patents have a lifetime. When is that lifetime going to come up? When does that expire? Are you going to have exclusivity? Are you targeting orphan? Are there fast track? There's a lot of different things that you need to think about. So, the advice, I think sort of the take home here is soak up as much of this sort of in this room kind of free knowledge you can, become as educated as you can, and then make sure that you find, somebody who can help move your technology forward and that you're protecting it in the right way, because you think it's expensive up front, wait until you have to fight all of the patents that you already thought were really cool, and that costs even more money. So if you do it right in the first time, you will ultimately, I think, save funds.
Thanks, Nicole. That was great. What you had said about your patents coming back to haunt you, that that resonates. I don't know if everyone in the room understood exactly what that meant, but I think part of, I think that ties into prior art searching as well. And I want to make sure we're not confusing freedom to operate and prior art searching. Peter, do you want to talk a little bit about prior art searching and if that's something that they should be thinking about at a startup stage? Or
I think as a way to get a handle on what your competitors may be doing, the pace of their filings, the content of their filings. I think you could learn a lot with prior art search beyond the substance of what's being filed. So the pace of their filings, how often do they file? What am I up against? Someone who's filing on every nook and cranny? That's putting up quite a fence. And certainly the content of what they're filing, it may lead to good competitive intelligence. So yes, absolutely. Searching beyond what you would think, right? So can I get a patent over what's out there? There's so many more gems out there in doing that. What was the other thing?
I don't remember.
Yeah, okay.
that was a great answer. Wait, so we have this huge outline. I know I'm never going to get to all of it, but I do want to touch on assignments or any other types of contracts that anyone thinks are interesting. Well, no contracts are interesting, but assignments are very important. And I think especially in this context, and Diana, you can talk about this too, you have to make sure that you own what you think you own, and not everyone owns what they think they own. And we need to have the right documents in place to be able to show that. And I know that's very important from your perspective, Diana. I don't know if you want to chat about that a little bit.
Yeah, I mean, I think, first of all, are you taking somebody else's IP and applying it in your particular situation? That obviously creates a lot of problems. So you have to make sure that you have very clear ownership over what it is that you're utilizing. So an example might be if you come out of a university, do you actually have all the documents in place that give you the right to claim that this is IP that you're going to use to commercialize? So there's that side, which is, making sure that your IP is free and clear for you to use. And then there's the second side, which is making sure that nobody takes it from you, right? And in the patent filing is sort of the nobody takes it from you side, but you also have employees, you have, contractors, you have people who consultants, and you kind of have the investors will look to make sure that if you're relying heavily upon any of these people, that you have the right agreements in place to protect you. Key employees, that's another key thing, which is a company is only as good as its key employees. So you have to make sure that that they can't just walk out the door and start another company doing reasonably the same thing and be one of your competitors within a short time frame. So there's many different aspects of making sure that your agreements, that the strategic agreements are in place and that they're strong enough to protect what you need to protect, that the investors will definitely want to look at. And that's usually in a data room. And so if you're organized in terms of your capital search, you'll have a data room and you'll have these key documents in that data room.
I have a number of anecdotes. I'm not going to use them all, but ownership and chains of title. I represented an acquirer of a business that was made up of at least 100 separate companies, each of which had been bought and sold for many years prior. And I remember getting into what turned into a shouting match, unfortunately, in Chicago for the better part of a day with the general counsel of that company, that I needed every document because I had to be able to roll up every one of those companies up to the seller. And it's very important. I've had other instances where a client of ours a business manager, one of the business units went rogue and bought a business from an individual, right, in Louisiana. And I don't know why I mentioned that like that, but in Louisiana, I'm sorry if
also
anyone's,
can't-
I
I
work
can't
there. I'm
imagine
sorry if
there-
anybody.
I can't
no, I'm not
imagine
like
you
that.
in a shouting match with anyone. That's the part I'm stuck on.
I have my trigger moments. Anyhow, this fellow sold. It was a handshake deal. So then he passes away. Then somebody buys the company that bought that patent that many years ago, and I can't show that we own it. And that held up like $100 million deal. So they're very important to underscore what you said. The other thing I want to add is many young companies start their IP comes from university, and that what flows with that is often what's called at the top of the page, the first page, exclusive patent license or exclusive license. Exclusive. The most that means exclusive. But if you read the document, you realize that the university has retained rights. Therefore, it's not an exclusive. So there's many instances where you can't sue without informing them. You basically have a partner, and it's the university. And so don't be fooled by the name of the agreement. Read the agreement. Is the quick advice I could give in that regard.
Nicole, I think you have a lot of experience in this area, right? Like pulling, because when we had a pre-call, you had a lot to say about as startups coming off of universities. I don't know if you want to add to that.
Yeah, I mean, I guess in terms of making sure that you have licenses in place and that you actually have the IP that you're claiming that you have. Oftentimes as a small business, you're like, all right, well, I don't really need it now, or I'm going to negotiate it. And you're talking to people like you already have it. That process can take a long time and a lot of back and forth. And even in a grant application, in an SBIR, STTR, you may need to prove that you have the license for that and what that license looks like and what those agreements look like. And does what are you giving in exchange for that patent? Is there IP? I mean, not IP, is there, equity that's being given in exchange for that patent? What is the field of use that you're claiming, right? Like, so I have a patent and we're taking that for an artificial retina, but we can also use it for other different fields. Do I own all of that? Do I own a part of that? Understanding that is really important. Could the university license that same patent out to somebody else and a sub license? And could they be doing something similar to what you're doing? Understanding all of that very early on is really important. So it's not something you want to just go in there and say, hey, all right, I need this patent. It's really important. I'm getting a grant tomorrow. Can you just sign this away? Don't do that because you will regret that. And then when you get to the diligence process and you have to show that whole chain of transaction, that's going to be a problem. Other things to think about when you're licensing, who's paying the patent costs? Do you start to take some of those patent costs to the university? Are they paying it? Is it reimbursable? Do you owe them what they've already put back or spent on those patents? All of this is important as you're going in there and negotiating. And I think the other thing when you're going in there and having those conversations, talking to a lawyer ahead of time, so you know what you can negotiate. What is even on the table for you to think about? Sometimes you'll get a blanket license agreement and 50 other people from the university have signed something similar. But there are things within each one of those that you can negotiate, and understanding what you can and cannot, I think is really important. Fortunately, I had a great experience with licensing our technology from the university, but I've heard a lot of horror stories, and all of those things I think are important as you're navigating that process.
I would say the biggest trick in the book is to say, this is our standard agreement. Negotiate.
Does anyone ever worry about, or Peter, should we be worried about former employers potentially being owners of the technology? Because I think we all think about, well, okay, if we're coming out of a university, then we need to make sure that we actually can do what we do. But what about if I'm coming from not a university, but say another company, a bigger company, a different company? How do we know that we haven't already, as inventors, assigned our invention to a former employer, and that's going to come back to haunt us someday?
Yes, that's a very active area right now. So what inventor leaves company A, goes to company B, and they had assigned their rights to company A. That happens a lot in certain industries, and I think here in the life sciences industry, folks are jumping from company to company. You see that quite a bit, and in California, you see it a lot in social media and that world. Should you be concerned? Yes. If you've assigned your rights, there's a thing called assigner estoppel. You can't go back and challenge that patent application. You can't bring those ideas that if it's not patented, if it's just information, you can't go to the new company and share those ideas. I have witnessed both. I have witnessed kind of pre-speakers go from company to company and share ideas, and that's not pretty. And I've witnessed great integrity where ideas came up from a former employer of the companies, and that person sat in the room and didn't say a word. And direct questions put to them, and they didn't say a word. So it's an issue. It's a real issue, and we've seen it. There's a case that's gone up to the Supreme Court, came back down, and where assigner estoppel was shown. It can happen.
It's a tricky area though, because when you specialize in something, you specialize in it, right? And then
This is true.
you go off from big company
Yeah.
A to startup B. Kevin, I don't know, not to put you on the spot. Do you have any thoughts on that topic about moving from one to another,
Yeah.
but being a specialist?
Yeah. So there's specialist and then there's specialist. To be a little bit more specific, most of my experience, most of the people I work with are in med device. But med device is big. Biotech is big. I would say if you're a specialist in, say, ALS, and some novel drug compound, I wouldn't necessarily look to target your next company if you're looking to invent being in a new drug compound for ALS. There's a whole broad swath of what you can look at that's adjacent that would put you outside of the range of what what IP you could trip on. For our case, within the employee agreement, part of that is when someone starts to put a list of any patents that they have from former employers, and that's to protect them and us. In the event that there's any kind of crossover within technology. And certainly if there's invention happening, we'll kind of keep people out of it if they seem to be in the same ballpark. For the most part, we've been able to avoid that. But it's certainly a watch out and something we're very conscientious about through both hiring and as we put together patents.
I have written letters for companies to use in both situations and representing employer and employee. The employee who's leaving your company should be debriefed and should be reminded of their obligations of confidentiality to the company, and then a letter followed to the new employer to let them know that this employee you just hired is obligated in these areas and spell them out to our company. I think it's a prudent thing to do these days, just to remind both parties should something happen down the road.
So we are running out of time. I actually don't have a clock, which is why I keep asking Peter for his watch. Here's what 2 minutes. That's the hurry up and be quiet warning. Here's what I'll say. With respect to questions, feel free to come up to us after. Also, our firm, we're going to be over at Empire across the street having a networking reception after party. I've been instructed to invite everyone in this room because you've all been such a good audience. So that'll be right after this. And does anyone on the panel want to give any last minute words of, no pressure, words of wisdom, things you think you wish you knew, pitfalls, things to watch out for?
I mean, I would just say, which has been my theme throughout, basically, sort of, if you want to raise capital, and it's a big if, may not necessarily want to raise capital, but if you want to raise capital, you can be so excited about your company, but you still have to think about the opportunity from the investor's perspective. And the investor really wants to know, how are you / they going to make money off of your activities? And that's really something to really understand before you start to go raise capital, because your company can be extremely exciting, but the investor has a pretty focused question for you.
Well, thank you to Startup Boston for having us here. Thank you so much to the panelists, and thank